Good afternoon, Eric Cherry, MP Weiss Law, South Euclid, Ohio. One of the topics that comes up a lot with new people that come to the law firm is a legal concept called res judicata. And before you turn it off, this matters to you in your family law case as well. It often happens that family cases in particular, but really any sort of legal case, same parties can come back to court over and over and over again in a family case during the child's minority while they're still in school and the court still has jurisdiction to handle parenting issues. Res judicata means let the decision stand. How it is applied generally in a family law case is that the court is going to restrict your ability to present evidence prior to the last time you were in court. So they don't want to hear about everything that happened in your relationship way back several years ago, or they don't want to hear about the stuff that led you to file your last motion 2.5 years ago. What they want to hear about is current events. And so they are going to restrict you from introducing evidence of things that may have occurred prior to the last court order. How does this usually manifest in the cases that I have? For example, the other parent is a drug addict. 5 years ago, they went to drug treatment. Well, when was your last court order? 2.5 years ago. Did you raise the fact that they were in treatment at the time you were in trial last time? No. Well, I hate to tell you, but that issue is gone now. You can raise what happened in the last 2.5 years. Maybe they went and got another DUI or something. Maybe they went to a new inpatient treatment program, something along those lines. But anything that happened prior to the last time you were in court is generally not going to be admissible. And this also relates to the decision whether or not to settle a case. Perhaps you do have a good fact and you're in the middle of litigation, coming up towards the end of a case, and you're sitting down deciding whether to settle a case. Maybe the person who's doing the investigation in your case and making recommendations to the court doesn't consider that particular fact that you think is a good fact to be all that important to their recommendation. You have to make a decision then. Are you going to go to trial, present that fact to the court and hope for a different result? Or are you going to accept the guardian ad litem's recommendation or whoever's doing your investigation and sign some sort of agreement? Because if you do the latter, you are waiving that fact. Whatever good fact that was, it is gone now. And you can't introduce it again in any future proceedings. This is important as an evidentiary rule to make this determination with your attorney of record before you decide to go to trial or to settle a case. If we can help you in any way on this issue in your divorce case, feel free to give me a call. My name is Eric Cherry, MP Weiss Law, South Euclid.